Good day, sir. Good day, everyone. We are the Group 6 and we are going to report about Module 22 entitled Recognizance. Here are the learning targets. In the end of the module, students will be able to understand and interpret the salient provisions of RA 10389. Republic Act 10389 is an act institutionalizing recognizance as a mode of granting the release of an indigent person in custody as an accused in a criminal case and for other purposes. So, when we say indigent person, it talks about to the people who are very poor and do not have enough money to pay for bail, to pay for private lawyer, and other legal expenses in court proceedings or in a criminal case. So, Republic Act 10389, this law allows poor person or indigent persons who are accused of a crime to be released from jail without paying bail. Instead of paying money, the court can release them through recognizance, which means a responsible person within the community, organization, or local officials promises that the accused will appear in court when required. In Section 1, it talks about the title of the act itself. This act shall be known as the Recognizance Act of 2012. In Section 2, Statement of Policy, it is declared policy of the state to promote social justice in all parts or in all phases of national development, including the promotion of restorative justice as the means to address the problems confronting the criminal justice system, such as protracted trials, prolonged resolution of cases, lack of legal representation, lack of judges, inability to post bail bond, congestion in jails, and lack of opportunity to reform and rehabilitate the offenders. In consonance with the principle of presumption of innocence, the 1987 Philippine Constitution recognizes and guarantees the right to bail or to be released on recognizance as may be provided by law. The principle of presumption of innocence means that a person accused of a crime is considered innocent until proven guilty by the court. Because of this principle, the 1987 Philippine Constitution guarantees the right to bail or to be released on recognizance while the case is being tried. So as we all know, bail means the accused can temporarily leave jail by paying a certain amount of money, while the recognizance means a person can be released without paying certain amount of money, but a responsible person or organization promises that the accused will appear in court when required. Those charged with life imprisonment or reclusion perpetua to be released on recognizance before conviction by the regional trial court, irrespective of whether the case was originally filed in or appealed to it upon compliance with the requirements of this act is hereby affirmed, recognized, and guaranteed. So first, the law says that a person accused of a crime has the right to be released on recognizance before they are convicted. This means they can leave jail without paying bail while their case is still being decided in court, as long as they follow the requirements of the law. However, this does not apply to people charged with very serious crimes that are punishable by life imprisonment or reclusion perpetua. These are severe penalties, so the accused in these cases usually cannot be released through recognizance. The law also states that the regional trial court can allow the release on recognizance whether the case started in the court or was appealed to it from a lower court. As long as the accused meets the requirements of the law, the right to be released on recognizance is recognized and protected. In Section 3, it talks about what is recognizance. Recognizance is a mode of securing the release of any person in custody or detention for the commission of an offense who is unable to post bail due to abject poverty. So in simple words, if a person is arrested and detained for a crime but cannot afford bail, the court may allow them to leave jail without paying money. Instead, a responsible person such as barangay officials, barangay chairman, organization, or community leader promises that the accused will attend all court hearings or proceeding. The court where the case of such person has been filed shall allow the release of the accused on recognizance as provided herein to the custody of a qualified member of the barangay, city, or municipality where the accused resides. It means that the court handling the case can allow the accused person to be released from jail through recognizance. Instead of staying in detention, the accused will be placed under the responsibility or custody of a qualified member of the barangay, city, or municipality where the accused lives.
So, Section 4, Duty of the Courts. For purposes of stability and uniformity, the court shall use their discretion in determining whether an accused should be deemed an indigent even if the salary and property requirements are not met. The courts may also consider the capacity of the accused to support not just himself, herself, but also her family or other people who are dependent on him, her for support and subsistence. So, kanang pasabot ani ay kabalo man ta nga natay mga certificate of indigency, especially sa mga uban nga nagatabang sa public attorney office. Tan-awon pud sa korte ang capacity basig daghan pud kag utang or naa kay mga kamag-anak or pamilya or nasa abroad nga ikaw pay nagapadala og kwarta, so dili kinahanglan nga pobre ka para mahimong indigent. Other relevant factor and condition demonstrating the financial incapacity of the accused at the time that he is facing charge in court may also be considered by the court for the purpose of covering as many individuals. Dili lang gamay ang atong income, daghan pud tag utang or mga bayro nun like expenses, taxes, or mga insurance. So kana siya i-consider na sa korte. So section number 5, this provision explain when a person who is arrested or detained can be released without posting bail based only on promises and affair in court called recognizance. So a person who is in jail while their case is ongoing has the right to be released and recognizance if the criminal charge is not punishable by death, reclusion perpetua, imprisonment up to 40 years, life imprisonment. So ang applyan sa sa isa ka offender mo ni siya ang Metropolitan Trial Court o Municipal Trial Court o Municipal Circuit Trial Court. So mo na siya, the accused may apply for recognition before or even after conviction. So pwede siya ka-apply, pwede siya ma-release kung mo kuan sa promise nga pagtawagon sa hearing mo tungag yun siya.
Good day everyone, I am MABAO and I am here to discuss about the section 6, which is the requirements. So the competent court where a criminal case has been filed against a person covered under this act shall upon the motion order the release of the detained person on recognizance to a qualified custodian, provided that all the following requirements are complied with. So the first requirement is a sworn declaration by the person in custody of his or her indigency or incapacity either to post a cash bail or proffer any personal or real property acceptable as sufficient sureties for a bail bond. So this means that a detainee must declare under oath that they are indigent or poor or otherwise unable to post a bail, so they cannot offer cash or property as a surety. Next is a certification issued by the head of the Social Welfare and Development Office of the municipality or city where the accused actually resides that the accused is indigent. So this means that the local or social welfare office must confirm that the accused is indeed indigent or poor. Letter C is the person in custody has been arraigned. So this means that the detainee must have already been formally charged in court. Next requirement is the court has notified the city or municipal sanggunian where the accused reside of the application for recognizance. So this means that the local legislative body or the sanggunian is informed of the application for recognizance so they can act on it. Next is the sanggunian shall include in its agenda the notice from the court upon receipt and act on the request for comments or opposition to the application within 10 days for receipt of the notice. So the action of the sanggunian shall be in the form of a resolution and shall be approved by the mayor and subject to the following conditions. So the first condition is that any motion for the adoption of a resolution for the purpose of this act duly made before the sanggunian shall be considered as an urgent matter and shall take precedence over any other business therefore, provided that the special session shall be called to consider such proposed resolution if necessary. So this means that requests under this act take priority over other council's business. So a special session may be called if needed. Next is the resolution of the sanggunian shall include in its resolution a list of recommended organizations from whose members the court may appoint a custodian. So this means that the council provides a list of qualified custodians like individuals or organizations from whom the court may appoint one. Next is the presiding officer of the sanggunian shall ensure that its secretary shall submit any resolution adopted under this act within 24 hours from its passage to the mayor, who shall act on it within the same period of time from receipt therefore. So this means that the presiding officer should ensure that the council secretary submits the resolution to the mayor within 24 hours. Next is if the mayor or any person acting as such pursuant to the law fails to act on the said resolution within 24 hours from receipt therefore, the same shall be deemed to have been acted upon favorable by the mayor. So this means that if the mayor or any authorized person does not act within 24 hours, the resolution is automatically considered approved. Next is if the mayor or any person acting as such pursuant to the law disapproves the resolution shall be returned within 24 hours from this disapproval therefore to the sanggunian presiding officer or the secretary, who shall be responsible in informing every member therefore that the sanggunian shall meet the special session within 24 hours from receipt of the veto for the sole purpose of considering to override the veto made by the mayor. Its purpose is to give the resolution to the sanggunian of the municipality or city that they should consider final and not subject to the review of the sanggunian panlalawigan, a copy of which shall be forwarded to the trial court within 3 days from the date of resolution. Next is if the accused shall be properly documented through such processes as but not limited to photographic image, reproduction of all sides of the face, and fingerprinting, provided that the cost involved for the purpose of his subsection shall shouldered by the municipality or city that sought the release of the accused as provided herein. Chargeable to the mandatory of 5% calamity fund in its budget or to any other available fund in its treasury. So, the accused should be properly documented because the accused isn't just to let go, they must be booked similarly to a standard arrest. So, they must provide fingerprints, photographs like mugshots in any angles. Next is the court shall notify the public prosecutor of the date of hearing, therefore within 24 hours from the filing of the application for release on recognizance in favor of the accused. So this means that the public officer or the public prosecutor should ensure that it is not blindsided. So once an application is filed, so the prosecutor is notified within 24 hours, and the hearing must then happen between 24 and 48 hours after the notice. So provided that such hearing shall be held not earlier than 24 hours and not later than 48 hours from the receipt of notice by the prosecutor. So, provided further that during said hearing, the prosecutor shall be ready to submit a recommendations regarding the application made under this act, wherein no motion for postponement shall be entertained.
Good day, I am Sarmi M. Kaipang, and I will be the one who will discuss the Section 7 under the Republic Act 10389, which is the disqualification for release on recognizance. So the following circumstances that I will be tackled are valid grounds for the court to disqualify an individual for release on recognizance. So the first disqualification is when the accused made an untruthful statement on his or her sworn affidavit, which prescribed or required by the court, then he or she will be disqualified for release on recognizance, because on sworn affidavit it should have truthful details of the person, identity, residence, or personal circumstances. So when the court finds that the accused intentionally provide false statement which shows dishonesty or lack of reliability, which the court may refuse to release them. So the second disqualification is when an accused is a recidivist, quasi-recidivist, an habitual delinquent, and has committed a crime aggravated by circumstance of reiteration. So this four is forms of repetition. So when we say recidivist, this refers to the person upon the trial for one crime has already been convicted by final judgment of another crime covered under the same title of the revised penal code. For example, if you are convicted by final judgment of robbery which covered or under the crimes against property, and then upon release you committed another crime which is theft, which also falls under the crimes against property. So upon trial, the court see that you have already been convicted of a robbery before, in which the two crimes falls under the same title of the revised penal code. That's one that they will consider a recidivist. So when we say quasi-recidivist, this refers to the person that committed another felony while serving the sentence or upon beginning to serve the sentence. And next is habitual delinquent. When we say habitual delinquent, this refers to those persons within the period of 10 years you committed the certain crimes such as serious less serious physical injuries, theft, estafa, falsification, and robbery, in which you are found guilty of these crimes for the third time. Next is reiteration. Reiteration means is when the offender previously punished of an offense to which the law attach an equal or greater penalty, or of two crimes which the law attach a lighter penalty. So the third disqualification is when the accused is previously escaped from legal confinement or evade his or her sentence or violate the condition of recognizance or bail without valid justification, which may disqualify them on release on recognizance, because this shows that they don't follow the rules of the court and may attempt to escape if released, and the court believe that they will not appear or return on court trial. So the fourth disqualification is when the accused committed a crime while already given a chance to reform through probation, parole, or conditional pardon, which shows that they abuse the privilege that was given to them. Due to this, the court may believe that the accused cannot be trusted or cannot be given an opportunity again to be released. And also this shows that they disregard the law and the rehabilitation process. The next disqualification is when there is a probability of flight based on the personal circumstances or the facts surrounding the case. So if the court believes that the accused might run away or avoid the trial or flee, then they will not be released on recognizance. It will be based on the personal circumstances or those factors that surrounding the case that might indicate that the accused might flee instead of appearing on the court. If there is a high risk of flight, then the release is unsafe. Next is if there is a high risk of the accused committing a crime again while the case is pending. So if there is a strong or a valid reason to believe that the accused might commit another crime if released, then the court may deny the recognizance, because this is the matter of public safety. So if there is enough evidence that will tell that the accused might commit another crime if released or would be a danger to the community, so the court prioritize the protection of the public safety rather than the temporary release of the accused. So the last one, disqualification, is having a pending criminal case in court with the same or higher penalty to the new crime he or she accused of. So if an accused have another criminal case that is pending in the court, so she or he will not be qualified of release on recognizance, because this indicates that the accused will continuously have involvement in criminal activities, making the release risky. And also many or multiple charges increase the incentive to flee or hide. It is also signals a pattern of behavior that indicates that the accused is not suitable for a non-monetary release.
My name is Serge Jane C. Pioquinto. So my topic would be about the Section 8, the qualifications of the custodian of the person released on recognizance. So this explains who can be the custodian of a person who is released on the recognizance. So a custodian is the person who will take responsibility for the accused while they are temporarily released from jail. Example cases of children in conflict with the law as provided for the Republic Act 9344. And the custodian of the person released on recognizance must have the following. So This means that this rule does not apply to minors who committed an offense because they follow a different law and a process under the Juvenile Justice Act. So the letter A would be a person of good repute and probity. So this means that the custodian must have a good reputation, honesty, and integrity in the community. So the court chooses someone who is trusted and respected so they can properly supervise the accused. So for example, for this is the barangay official, a community volunteer. The court believes that a person with good moral character will take the responsibility seriously. So the next one would be the letter D. So a resident of the barangay where the applicant resides. So this is important because the custodian can be easily monitor the accused, and also they are close enough to know the accused's activities, and also the accused cannot easily disappear. And the next one would be the it must not be a relative of the applicant with a fourth degree of the consanguinity or affinity. So the accused, the custodian cannot be close to a relative of the accused. The law avoids relatives because they might be biased or too protective. The relatives will be like parents, siblings, grandparents, uncles, and aunts. So the court wants someone who can be objective and responsible, and not someone who may hide the accused. So the next one would be the letter D. So it must be belong to any the following sectors and institutions such as the church, academic, social welfare, and other organizations engaged in the rehabilitation of offenders duly accredited by the the local social welfare and development office. So the custodian must belong to a recognized sector or organization in the community, and these groups are chosen because they are known for helping people and also promote good behavior. And if no person in the barangay where the applicant resides belongs to any of the sectors and institutions listed under the paragraph and above, and the custodian of the person released on the recognizance may be from the qualified residents of the city or municipality where the applicant resides. So if no one in the barangay belongs to these sectors, and if the law required the custodian to be only from that barangay, many poor accused persons would remain in jail simply because no qualified custodian is available, even if they deserve a temporary release. So the law allows the custodian to come from another barangay with the same city or municipality because this ensures that the accused can still benefit from recognizance even if their barangay has no qualified custodian, while making it sure that someone responsible and supervises them, and also ensuring justice and fairness for the accused.
Section 9. Duty of the custodian. The custodian shall undertake to guarantee the appearance of the accused whenever required by the court. The custodian shall be required for execute an undertaking before the court to produce the accused whenever required. The said undertaking shall be part of the application for recognizance. The court shall duty notify within a reasonable period of time the custodian whenever the presence of the accused is required. A penalty of 6 months to 2 years imprisonment shall be imposed upon the custodian who fail to deliver or produce the accused before the court upon due notice without justifiable reason. What the custodian must do? The custodian, the person responsible for the accused, has to make sure the accused shows up in court when needed. They must sign a paper promising this to the court, and this promise is part of the request to let the accused be released under their care. The court will tell the custodian in time when the accused needs to be in court. If the custodian doesn't bring the accused to the court after being told to, and his and has no good reason, they can put in jail for 6 months to 2 years. Section 10. Role of the probation officer. Upon release of the person on recognizance to the custodian, the, the court will issue an order directing the probation office concerned to monitor and evaluate the activity of such person. The probation officer concerned shall submit a written report containing its findings and recommendation on the activities of the person. Release on recognizance on a monthly basis to determine whether or not the condition for his or her release have been complied with. The prosecution, including the private complainant, if any, shall be given a copy of such report. What what the probation office does when someone is released under a custodian's care, the court will tell the probation office to watch and check on that person. The probation office must write a report every month about how the person is doing, saying if they're following the rules of their release. The people who brought the case, including any private person who filed a complaint, will get a copy of this report.
Good day everyone, I am EDERANGO and I will be the next reporting. Section 11, Arrest of a person released on recognizance. So Section 11 explains when a person who was already released on recognizance can be arrested again by order of the court. Recognizance means the accused was temporarily released without paying bail because a responsible person or authority promised that the accused will attend all court hearings and follow the court rules. However, the court can order the arrest of the accused and place them back in detention if any of the following happens. First is letter A. If someone submits a sworn statement to the court with a valid reason, the court may conduct a short hearing to check the truth. The accused will be given a chance to explain. If the court finds the complaint true or reasonable, the court can order the arrest of the accused. Letter B. If the accused does not attend the trial or court hearings, even though they were properly notified and they do not have a valid reason, the court can order their arrest. Letter C. If the accused commits another serious offense that shows bad character, for example, theft or fraud, while the case is still ongoing and the public prosecutor or the mayor recommends the arrest, the court can order the accused to be arrested again. Lastly, letter D. If the accused threatens, intimidates, stalks, or bothers the complainant, prosecutor, or witnesses, the court can order their arrest to protect those involved in the case. So once the court issues the order of arrest, the accused can also be arrested by a private citizen, which is called a citizen's arrest, according to the rules of court. For short, even if the accused was released on recognizance, the court can arrest them again if they skip court hearings, commit another crime, arrest people involved in the case, or if there is a valid sworn complaint against them.
So in my last part, Section 12, no release on recognizance after final judgment or commencement of sentence exemption. So the benefit provided under this act shall not be allowed in favor of an accused after the judgment has become final or when the accused has started serving the sentence. So which means the benefits of the law, like release on recognizance, cannot be given to an accused person. Once the court decision is already final, or if the person has already started serving the sentence in jail. So, in short, if the case is still ongoing, the accused may be released on recognizance. But, if the court has already made a final decision and the person is already serving the penalty, the law will no longer apply. So, example, Juan is still on trial, he may qualify for release on recognizance. But if Juan is already convicted and serving his sentence, he cannot use this law anymore. So, number 2 is provided that this provision shall not be applied to an accused who is entitled to the benefits of the probation law. If the application for probation is made before the convict starts serving the sentence imposed, so meaning even if the judgment is already final, the probation will not apply if the accused is qualified for probation and files the application for probation before starting to serve the sentence. So, in short, normally a person cannot get the benefits of recognizance after final judgment. But if a person qualifies for probation, they can still apply as long as they apply before they start serving the sentence. Example, the court finds Pedro guilty and gives him 1 year sentence. So before going to jail, Pedro applies probation. So because he applied before serving the sentence, he may still receive the benefits of probation. So and last part is, in which case the court shall allow the release on recognizance of the convict to the custody of qualified member of the barangay and city or municipality where the accused actually resides. So meaning, if the convict person applies for probation before starting the sentence, the court may allow the person to be released on recognizance. So the person will be placed under the custody or probation of a qualified member of the barangay or city or municipality where the accused lives. So, ug asa nagpuyo ang accused. So, in simple explanation, the court can temporarily release the convicted person or the person will not go to jail immediately. So, ang person, dili siya maadto dito sa jail. So, instead, they will be under the supervision of responsible local official or qualified community member in the place of residence. So, example, Pedro was found guilty in court and sentenced to 1 year prison. Before they started serving his sentence, he applied probation under the Probation Law of 1976. While the court is reviewing his probation application, the judge allowed Pedro to be released on recognizance under Republic Act 10389. Instead of staying in jail, Pedro was released to the custody of the barangay captain of Barangay Isidro, where he lives. So, the barangay captain is responsible for supervising Pedro and making sure he follows the court's condition while waiting for the probation decision. So, that's all. Thank you.